I think you can tell that I'm having some issues with my voice, but I want to welcome all of you here. This is the sixth Education Spotlight hearing that I've called, and that's because this regime, the Trump regime, is intent on getting rid of the federal support for education. Now, I normally would introduce all of the witnesses, so I thank all of you for being here, but I'm going to ask all of you, when you give your remarks, to introduce yourselves, a little bit of your background, and then go into your remarks. As I said, I normally would extend the courtesy of doing that, but you can tell that my voice is not how it normally is. Okay. I just want to start, though, with some opening remarks. As I mentioned, this Trump regime is very intent on eliminating the Department of Education, but they can't do it because it's Congress that created the Department of Education. Only Congress can get rid of it. However, they can do a lot of other things, such as dismantling various programs so that they can weaken how education is supported in our country. So I thank each of you for focusing today on what's happening with IDEA. So it started with Donald Trump's illegal executive order dismantling the Department of Education. As I mentioned, he can't do that, but he has entered into things called interagency agreements. You all know what I'm talking about, IAAs, to move programs from Department of Education to other departments, some 5 or 6 other departments. These agreements are not just harmless administrative shifts, and the results will weaken and remove federal government support for public education in our country. And today we are here to discuss 2 of these agreements and the impacts on students with disabilities. First, they're transferring the Office of Special Education and Rehabilitative Services, or OSERS, to the Department of Health and Human Services, HHS. And second, moving the Office for Civil Rights, OCR, to the Department of Justice, DOJ. 50 years ago, Congress passed the IDEA, Individuals with Disabilities Education Act, 50 years ago, to help guarantee that every child, regardless of disability, zip code, or family income, had access to free and appropriate public education that responds to their needs. And currently, there are more than 8 million students with disabilities who receive services under the IDEA. Since the IDEA was created, the Office of Special Education and Rehabilitation Services, or OSERS, as I mentioned, has been responsible for ensuring that schools comply with IDEA so that students get the services that they need. Handling that responsibility to the Department of Health and Human Services, HHS, proves that this regime really doesn't give a hoot about students with disabilities. HHS has a zero experience dealing with IDEA. And with HHS Secretary Robert Kennedy Jr. publicly calling autism an individual tragedy that destroys families, he certainly doesn't think of children with disabilities as a group of students who, under IDEA, should get the educational support they need. He thinks it's a tragedy. So handing over this program to HHS is not what we ought to be contemplating. So to make matters worse, the Office of Civil Rights, or OCR, the agency responsible for investigating violations of student rights, including special education access, which is really the problems with the very program we're talking about, is being moved to the Department of Justice. to their Civil Rights Division, which has been dramatically cut. So that division has already seen significant staffing cuts and was never designed to advocate for individual students. So considering the difference, while the Office of Civil Rights is required to review every complaint that it receives within the Department of Education, amounting to thousands of cases each year, the Department of Justice Civil Rights Division, by contrast, selectively picks a few dozen high-impact cases annually. It is not Department of Justice's job to investigate the thousands of complaints that comes into the Office of Civil Rights within the Department of Education. So guess how many thousands of backlog there already is? 23,000 cases within the Department of Education. All of these cases are going to be turned over to the Department of Justice. You can imagine what's going to happen to these cases. They're probably going to be dropped. They are not going to be investigated the way that they were, or they should be under the Department of Education. So what we are witnessing is nothing short of deliberate efforts to dismantle the programs that support students, and today, students with disabilities. So clearly, families in our country, 8 million students, they deserve an educational system that is going to provide their kids with the education services that is required under IDEA. And I hope that you will also, each of you will talk about what this means to states, to parents, to the state's education system, and all of the other aspects of what this kind of a transfer of this massive program will mean to the programs that I know you are very familiar with. And I just want to invite my colleagues. Jean, it's very clear that I'm having some issues with my voice, so I'm glad that everybody's. I know this is pretty ridiculous, but thank you for coming, and my two colleagues who are here. So as I said, I want to have each of you, we'll start from the left, go down the line, introduce yourself, and provide us with your testimony, and then I'll turn to my colleagues for their questions. But thank you both, Senator Whitehouse and Senator Shaheen, for being here. Go ahead.
Thank you, Senator Hirono. I appreciate the opportunity to join you and your colleagues today. Is that better? Okay. I appreciate the opportunity to join you and your colleagues today to discuss the value of the Office of the Special Education Programs, or OSEP, and why it must be preserved within the U.S. Department of Education. My name is Lori Vanderplug, and I am the Associate Executive Director for the Council for Exceptional Children, the largest professional special education organization dedicated to improving the results for students, infants, toddlers, and youth with disabilities and gifts and talents. I have served as a district special education director, a local special education supervisor, a special education teacher, an adjunct professor at a university in a special ed administration program. And in addition to my professional experience, I am the parent of an adult son with disabilities, which has provided me with valuable personal insights. I was honored to serve as the director of the Office of Special Education Programs from 2018 to January of 2021, under the first term of President Trump. States, districts, educators, families, and children with disabilities rely on OSEP to help improve special education nationwide as our field simultaneously advances through new research and faces persistent challenges. My signature effort at OSEP was the Attract, Prepare, and Retain initiative, and it was to address the persistent shortage of special educators, drawing on insights from OSEP's 2-year focus on strengthening personnel pipelines. I highlighted key strategies and leveraged points that states and local programs could use to improve recruitment, preparation, and retention outcomes. During that time, OSEP released 13 briefs to support state and local efforts to attract, prepare, and retain effective personnel serving children with disabilities across K-12, early childhood, and related services. While I was OSEP director, we implemented changes to strengthen transparency and collaboration in OSEP's monitoring process to move the system beyond compliance and toward results. We supported state leaders to identify areas of concern and provided targeted technical assistance. We implemented a framework that ensures all states are monitored within a reasonable time frame, increasing the frequency of monitoring. We tailored monitoring activities to each state's specific needs, embedding continuous improvement at the state level. I led OSEP during the COVID-19 pandemic. Holding a leadership position at that time put me at the table with consequential cross-departmental meetings, ensuring the disability perspective was represented as guidance was developed and statutes were being interpreted in the context of the pandemic. This internal collaboration across the agency is critical, just as it is at the school level, because children with disabilities are part of a whole educational system, not just special education. With the cuts that have already occurred and those proposed in the education budget, the kind of national leadership that I just described will be lost. There will be pockets of excellence across the country, while vast areas will struggle to meet basic requirements of the laws that serve children with disabilities. The field of special education will face a significant void in guidance and leadership that supports continuous improvement, something we are already seeing because of last year's reduction in force. OSEP's state monitoring cycle has also been significantly delayed and will continue to lag, weakening oversight. Meanwhile, states are now facing a significant uptick in complaints related to special education. Written state complaints increased by 46% from 2024-25 school year to the 25-26 school year, according to a survey of the states that CEC conducted this spring that yielded 31 responses. Despite the substantial increase, states are required to address each complaint within 60 days, even as they just in the education field nationwide experience staff shortages and high rates of staff turnover, making it extremely difficult to provide timely resolutions. This snowball effect will only get worse. There is a solution to this problem, and it lies with Congress. Members from both parties must stand up for infants, toddlers, children, and youth with disabilities by preserving the Department of Education and protecting special education programs from being transferred to another agency. We must resist the urge to make the fate of children with disabilities political and urgently remain focused on supporting outcomes for all children. Thank you.
Good afternoon. I'm Katie Neese. I'm the Chief Executive Officer of the ARC of the United States. The ARC is the nation's largest grassroots organization advocating on behalf of people with intellectual and developmental disabilities and their families. I've been in this role about 2.5 years. My previous position was as Deputy Assistant Secretary at the Office of Special Education and Rehabilitative Services, where I worked with practically everyone on this panel, and am glad to be here. I want to echo everything that Lori said, but certainly to point to your attention that Section 603 of Public Law 108-446 states, quote, "There shall be within the Office of Special Education and Rehabilitative Services in the Department of Education an Office of Special Education Programs, which shall be the principal agency in the department for administering and carrying out this title and for other programs and activities concerning the education of children with disabilities." I'd say that Congress has not altered this section of existing law, And yet the current administration on June 16th announced an interagency agreement that describes activities that appear to conflict with this requirement established in federal law. Obviously, the ARC does not support the transfer of these responsibilities to the Department of Health and Human Services, and I have 4 points for you to consider. First, as Lori mentioned, the expertise of staff at the U.S. Department of Education is essential for student success. This expertise has been honed over years and requires much more than knowledge about disability policy. And while it's true that education is primarily a state responsibility, it is also true that states must apply federal law, state law, and oftentimes local policies to each student with a disability. When I was at the department, one of the things was at the beginning of the second school year of COVID, and the personnel shortages in our country were especially profound then. And we had a lot of really honest, honorable people doing the best they could. They also didn't all know their roles and responsibilities under the law. And so rather than get mad at them for not knowing what they didn't know, we crafted general supervision guidance so that in one place, states and then districts and schools would know what their obligations were under the federal law. The department and its staff have spent the last several years educating states about their general supervision responsibilities, and we're just concerned that that is going to stop. The work is technical, and often local leaders need to understand how the pieces fit together. And the department's task falls into 2 primary categories: how the state ensures success for a specific child, and how the state ensures success for its education system. And they get this support directly from the staff at the U.S. Department of Education. Second, students with disabilities do not experience school in agency silos. A student who is denied services, disciplined for disability-related needs, or blocked from an accessible classroom needs one federal education system that can see the whole picture and act. Moving special education to the Department of Health and Human Services and civil rights enforcement to the Department of Justice would split apart the offices responsible for making disability rights real in school, leaving families chasing answers across the federal government instead of getting accountability from one education agency. Third, while there are real gaps in the effective implementation of this law, there is also clear evidence the law is working because the Department of Education is holding states to account for statutory requirements. A good outcome of this is the percentage of students with disabilities who graduate from high school with a standard high school diploma has increased more than 14% from school year 2014-2015 to school year 2022 to 2023, going from 66% to 75%. And as you know, getting a standard high school diploma can change the trajectory of your life. And we want more students leaving high school with that credential. Finally, families with students with disabilities have been harmed by the actions taken to dismantle the Department of Education. Beginning in March 2025 and continuing now, there are delays in investigation of discrimination regarding students with disabilities. There are delays in stakeholder response to technical questions. There is uncertainty about existing and new guidelines to assist states to understand their roles and responsibilities. There is uncertainty in the continued flow of federal funding for formula and discretionary grants. There is uncertainty at the school and district level of whether the law still applies, as demonstrated by families being denied initial evaluations for their child that we have heard from our chapters. Families being denied consideration of special factors like assistive technology in their IEPs, and families being denied timely action on complaints filed with the Office for Civil Rights. Simply put, this transfer is bad for kids with disabilities, it's bad for families, and it's bad for public education. Thank you.
Thank you, Senator Hirono. It's an honor to be here, although I wish the circumstances were different. My name is Valerie Williams. I served as Director of the Office of Special Education Programs, or OSEP, at the U.S. Department of Education during the Biden-Harris administration. I also previously worked on the HELP Committee doing disability policy and civil rights. And today I help states and school districts strengthen their special education systems and advocacy organizations strengthen their impact at hypocrisy consultants. Through all of it, the title that I carry that matters to me most is parent of a 15-year-old that happens to have Down syndrome. I'm going to start with the bottom line, which you already mentioned, the interagency agreements moving OSERs to Health and Human Services. It's being described as a paperwork change, a way to cut red tape. It is not. It's the quiet dismantling of the federal capacity that makes a 50-year-old civil rights promise real in an actual classroom. Most Americans have never heard of OSEP, and that's by design. When the plumbing works, nobody thinks about it. You only notice it when the water stops running. Here's what that invisible office does every single day. It administers roughly $15 billion, with a B, a year in IDEA funding. The dollars that help pay for special educators, occupational and physical therapists, paraprofessionals, and others. Just as important, this office provides thought partnership and support to states. It answers their hardest questions, funds the technical assistance centers, and parent training and information centers that administrators, teachers, and families lean on directly. And yes, it also monitors whether states are meeting their obligations. So there's a federal backstop before a family has to hire a lawyer. This expertise, built by people who have spent their careers
Thank you, Senator.
learning this law and earning the trust of state directors. Move that work to an agency that has never done it. Cut the staff who hold that institutional knowledge. And the law still exists on paper, but fewer and fewer people can make it real. And the destination matters. Special education is built on an education model. A child with a disability belongs in a classroom, learning alongside their peers. HHS operates on a health model. We are not trying to treat a diagnosis, we are educating children. Here's what worries me most. As someone who ran this office, the damage does not announce itself. The erosion of enforcement and support does not show up the week it happens. It shows up months later as a state that quietly stops getting monitored, a complaint that just sits, or a phone call that never gets answered. With less and less federal support, states are left to figure things out on their own, which produces a patchwork of attempts to figure out how to best provide supports and services. And a drift back toward compliance instead of outcomes, which my fellow panelists have already discussed. By the time it's visible, the child has aged out of the grade when the help that they needed would have mattered most. So I want to be clear about what I am asking and what I'm not asking. I'm not asking Congress to preserve a bureaucracy for its own sake. I am asking Congress to protect the federal capacity required to fulfill a civil rights promise. Congress created the Department of Education, and only Congress can dismantle it. The HELP Committee recently took the bipartisan step, and it was a step in the right direction. I am pleading that you continue in this direction and use every bit of power within your control to stop these transfers before the knowledge walks out the door. Because some of what is being lost cannot be rebuilt later. Once the experts are gone and the institutional memory is scattered, we cannot get it back with a memo. We just marked 50 years of this law. I hope that this is the year we can defend the floor that we have built and not the year that we let it crack. Thank you.
Thank you, Senator Hirono, for the chance to be here today.
My name is Seth Galanter. I'm a senior fellow at the Edley Center on Law and Democracy. Previously, I served in the Department of Education's Office for Civil Rights in both the Biden and Obama administrations as the Principal Deputy Assistant Secretary for Civil Rights. And at the beginning of my career, I spent almost a decade working in the Civil Rights Division at the Department of Justice. I've seen both agencies from the inside, and so I feel particularly entitled to address why these interagency agreement that education has entered into with DOJ is bad for the public and undermines the mission of both important civil rights agencies. OCR for more than 60 years has adopted a complainant-focused model. That's what makes OCR different than DOJ and different than OSERS. Every complaint received by OCR is assessed in conjunction with the parent or student or other complainant to see if it indicates a possible violation of civil rights laws enforced by OCR, including the disability protections of Section 504 and the ADA. If the complaint does so, OCR will open an investigation. OCR also adopted a regional office approach where complaints are processed and investigated by local federal officials or employees who remain aware of local conditions and controversies and have ongoing relationships with schools in the region. Given the unique individualized focus on complaints, OCR has sometimes struggled to implement its approach. Even when it had between 500 and 600 employees, it could not keep up with the tens of thousands of complaints it received every year. Investigations and resolutions were backlogged, follow-up was slow, but the basic idea of giving each complaint a fair appraisal, a fulsome investigation when it stated a claim, and an appropriate remedy based on the facts was the principle that guided OCR's decisions regarding where and how to allocate its resources. The IAA moves OCR's complaint screening and investigation functions to DOJ, along with the money to perform those tasks, but we have no idea who at DOJ will be doing this work. DOJ doesn't have a history of complainant-centered model. To the contrary, its history and culture is focused on impact litigation. It pursues consent decrees and court orders reserved for a small number of egregious or systemic cases. It often measures litigation and compliance in years, unlike the ability of OCR to rapidly resolve some complaints. The work DOJ does is extremely important, but it's not a substitute of the work of OCR for the parents and students who seek its help. Even prior to this agreement, the administration has significantly undermined OCR. In the March 2025 RIFs, 299 of its approximately 575 employees were laid off, and OCR closed 7 of its 12 regional offices. OCR also let $14 million in appropriated funds expire rather than spend it on protecting students. And OCR may leave even more money on the table in FY26. And the results speak for themselves. Between the beginning of the Trump administration and the end of 2025, OCR reached just 112 resolution agreements nationwide, the fewest in 12 years, and 78% fewer than reached in 2024 on the same budget. And there's very little reason to think OCR will do better this year. As of the end of July, OCR had resolved only 92 cases in the entire year, and over 30 of them were cookie-cutter anti-DEI resolutions about supporting Black and Latino students trying to get MBAs. At the rate that they're currently going, they will barely match the poor showing of 2025. For students with disabilities and their parents, who make up about half of OCR's complainants each year, OCR brought a significant expertise in special education and educational accommodations. As Valerie just said, we're going to lose those experienced career investigators and attorneys if these functions are transferred to DOJ. And there's a reason that Congress kept OCR and OSERS in the same building. School districts need one consistent answer on disability rights, not 2 agencies pulling in different directions. This coordination is going to be harder when responsibilities are spread among multiple agencies. splitting apart the offices that jointly protected students with disabilities, and undermining the civil rights educational rather than medical framing Section 504 and the IDA were built upon. OCR has never been perfect, but its imperfections were the imperfections of an agency trying to do too much with too little, not an agency abandoning its mission. The proposed IAA does not fix any of its problems, it deepens the problems. At a minimum, it will add years of delay while two agencies work out who does what and who will be hired to do it. And at its worst, it will extinguish the promise OCR has offered parents and students for more than 60 years, that whoever you are, your complaint will get a fair look, a real investigation, and a remedy grounded in the facts. That promise is worth protecting. Thank you very much.
Senator Hirono and members of Congress, my name is Elizabeth Tang, and I'm a senior counsel for education and workplace justice at the National Women's Law Center. For more than 50 years, NWLC has fought for gender justice in the courts, public policy, and our society. Thank you for this opportunity to testify today on the importance of keeping the Office for Civil Rights core functions at the Department of Education so we can protect equal opportunity for all students, including students with disabilities. Every year, OCR receives about 20,000 complaints from students and families alleging violations of their education civil rights. Disability discrimination has historically been the #1 category of complaints filed with OCR, comprising half of all complaints filed each year. Between 2021 and 2024, the number of disability complaints filed each year skyrocketed by 74%. These include complaints alleging seclusion and restraint, discriminatory discipline, and denial of a free, appropriate public education. I want to note that many disabled students face intersectional discrimination based on multiple protected traits. For example, disabled girls are targeted for sexual violence based on both their disability and gender. Girls are more likely to be sexually harassed and assaulted than boys, and disabled children are 3 times more likely than their non-disabled peers to be sexually abused, often because their abusers know that victims with disabilities are seen as less credible. But when schools fail to address sexual abuse of disabled students, many may file only a complaint of sexual harassment or violence, and these are subcategories of sex discrimination. So when we look at only the number of disability complaints filed with OCR, we do not see the full picture of civil rights violations experienced by disabled students. We must look at the entire picture. I now want to name 3 key reasons why the Trump administration's interagency agreement to transfer core OCR functions from ED to DOJ's Civil Rights Division, known as CRT, will be devastating for students with disabilities. While this unilateral transfer of authority is plainly illegal, I will focus my remarks on the direct and immediate harm to students. First, OCR addresses tens of thousands more complaints than CRT, as Mr. Glanter has mentioned. This is because OCR is legally required to review every single complaint it receives. In contrast, CRT has significant discretion to decline complaints. It pursues only a handful of education complaints each year, and these generally involve large-scale systemic violations, not individual incidents. In fact, due to capacity constraints, CRT has historically referred the vast majority of education complaints to OCR. And so sending OCR complaints back to CRT, as the Trump administration now seeks to do, is simply unworkable. Second, OCR's administrative process is easier and faster to use. Anyone can file an OCR complaint. You don't need a lawyer. The online portal is easy to use, and OCR resolves the vast majority of complaints through mediation or voluntary resolution agreements. When OCR is sufficiently resourced, this process can take as little as a few weeks or months. In contrast, CRT is primarily a litigation component. Litigation is inherently resource-intensive and regularly takes years to complete. Outsourcing OCR complaints to CRT means that even the few disabled students whose complaints are chosen for litigation must still wait years for their lawsuit to finish with no relief in the interim. Third, OCR primarily uses collaborative methods to secure compliance. With OCR, you can initiate enforcement proceedings, that is true, to terminate a school's federal funding, but it has rarely, if ever, done so. Instead, OCR has historically worked with schools, not only to reach voluntary resolution agreements when complaints are filed, but also to provide technical assistance to schools that proactively request it, so that we can prevent discrimination from happening in the first place. In contrast, CRT's primary method, litigation, is inherently adversarial. It is not positioned to provide technical assistance to schools, and schools are very unlikely to want to share information with an entity that may later decide to sue them. In summary, moving OCR functions to CRT means that tens of thousands of students' civil rights complaints will sit unaddressed every year. And as we know, these interagency agreements are part of the administration's larger attack on educational equity. From firing more than half of all OCR staff and shuttering 7 of 12 regional offices, which had served 46 million students across 27 states and territories, to weaponizing OCR against diversity, equity, and inclusion policies and transgender students. Meanwhile, Trump's OCR resolved 73% fewer disability complaints in 2025 than 2024. That is a shocking 13-year low. It also reached 0 resolution agreements involving seclusion and restraint of disabled students, sexual harassment or violence, racial harassment, or discriminatory discipline in all of 2025. Moving OCR functions to CRT will not make any of this better, not least because CRT has also been decimated, with 75% of staff leaving the office by the end of 2025. Behind every complaint of discrimination is a student who has experienced significant harm. Congress must rise to the occasion and ensure that the doors of educational opportunity are open to all. Thank you for your time today, and I urge you to take swift action to keep OCR's functions at the Department of Education. I look forward to your questions.
I thank all of you for just one. Senator Shaheen.
Thank you, Senator Hirono, for holding this session today, and thank you to each of the panelists for your testimony. I was glad to see last week that the Senate Help Committee voted 13-9 to prohibit the administration from moving the Office of Special Education and Rehabilitation Services to any other executive branch agency. And I think the knowledge and experience that you've shared in your testimony indicates why it doesn't make sense to change the way the agency is organized if we're going to help students with disabilities. Ms. Williams, one of the parents who wrote to me about moving the IDEA responsibilities to the Department of Health and Human Services said that she was concerned that 2 separate agencies would be responsible for general education and special education under the Secretary McMahon's plan. She shared that her son has Down syndrome, but that he was able to attend school with his peers and to be taught in an integrated setting, which I think we would all agree is one of the benefits of IDEA. So if the administration's plans to move special education services to the Department of Health and Human Services and to move general education to the Department of Labor do take place, can you talk about what other harms may occur to students with disabilities?
Thank you for that question. Having education, a couple things. One is that we have spent many years teaching states and districts how to include kids meaningfully and teach them. And when that only happens when, say, the Office of Elementary and Secondary Education and Post-Secondary and all the offices are under one roof. Then you can coordinate together. Special education has a tendency to be siloed, and putting special education in HHS and putting other offices in labor or other agencies will have the tendency to silo our students further. And we continue to say that students with disabilities are general education students first. But the schools and districts that serve them will not have the benefit of the resources that OSEP and the department broadly provide if you divide them up amongst a myriad of different agencies. So that makes everything more difficult to, makes the system slower, it makes it less certain, and that means that only the parents with resources are going to move forward to try to figure out what needs to be done, likely through litigation. So when we start scattering the different offices and, more importantly, the different people that have the knowledge and they know the pain points in various states and things that they're working on, and they're helping them through with that thought partnership, If all of that disappears, then parents don't know which way to turn, and everything becomes more difficult. And a year in the life of a student is forever, and kids don't have the time to wait while the adults that run the system figure out how to get it right.
Thank you. Ms. Neese, am I pronouncing your name correctly? You served as Assistant Secretary of Special Education and Rehabilitation Services for almost 4 years. You were responsible for both IDEA services and the program that supports people with disabilities trying to secure jobs. One of the mothers who wrote to me opposing the move shared how she thought her son's school had prepared him to be an active member of his community who could hold a job and pay taxes. Can you talk about what will happen to that aspect of the agency if the functions are split?
Thank you for that question. The issue of what happens when students age out of high school is one that we, in the last administration, spent a lot of time figuring out how to make it work better. Right now, under the law, students with disabilities are supposed to have transition services in their individualized education plan starting no later than age 16. And the vocational rehabilitation program is supposed to dedicate 15% of its federal funds, which is 15% of $4 billion each year, to paying for such services. Those two pieces have to come together, and we put very specific language in both the WIOA law and in IDEA to make that work. If you don't have those pieces knowing that they have to work together because they're in a different agency with people who don't understand that babies turn into adults and that people need supports along the way, and that their support needs are going to change, and therefore the systems need to have a different perspective about what their future is in the totality of them. The separation of these agencies and not having a systems perspective is going to make it even more difficult to implement.
Thank you. I've been in elective office now for 30 years, and starting with the state senate in New Hampshire, and IDEA has been an issue at every level where I have served. And the issue was not how is the agency organized. The issue was that the federal government, when it passed the IDEA law, promised to fund 40% of the law, and it's only funded about 15% at its height. And that's been the issue. It's not reorganizing it. Reorganizing it isn't going to provide any additional funding to help families and states deal with this issue. It's resources, and that's where we ought to be focused. We need to provide the resources and stop pretending that reorganizing it is going to make a difference. Thank you, Madam Chair.
Thank you, Senator Hirono, and also thank you so much to the witnesses for being here and bringing us together to speak about how this administration's interagency agreements will harm students with disabilities. I'm particularly concerned about moving the Department of Education's Office of Civil Rights to the Department of Justice. And last week, the HELP Committee advanced a bipartisan bill that would stop several of the IAAs, but OCR was not included. I co-led an amendment alongside Senator Murray to add OCR to that list because students with disabilities rely on OCR's enforcement process to protect their right to learn and feel safe in school. Mr. Galanter, you have a unique perspective as someone who has worked in both OCR and the Department of Justice Civil Rights Division, which would take over OCR's responsibilities under the IAA. For more than 60 years, is my understanding in your testimony, OCR has used a complainant-focused model. Can you compare OCR's model to how the Department of Justice Civil Rights Division processes discrimination cases and say why that difference matters and specifically why it matters for students with disabilities?
Thank you, Senator, and thank you for your support on the HELP Committee. Let me start by saying that both the roles that DOJ and OCR play are incredibly important, but they are quite distinct. The special role that OCR plays is particularly valuable for parents and students who don't have access to resources, who don't have access to lawyers, or who simply have a complaint and need help. And the OCR complaint process is one of the few places in the federal government that they can go in an education setting and get an individualized response. Now, they may not always like the response, but they will get their complaint heard, they will speak to a real human being about it, and if there's some merit to their complaint, there'll be an investigation. As my colleague said, oftentimes it results in voluntary resolution rather quickly in the process, and they get some real significant change in their child's life. DOJ performs an incredibly valuable function at a systems level. They look and they get lots of complaints and they sift through them, looking for patterns, looking for, great facts, or, novel questions of law that they want to establish a new rule on, and they work aggressively to vindicate the rights of kids, but they do it at a macro level. They do it in cases that takes years, that lead to settlements that say 90% of kids should get X within, 2 years, or, we want substantial compliance with this by 2030. And that's great for the system, but there's an individual parent there who's part of the 10% who's not getting the immediate relief, and they could always come to OCR. There's no plan that they've revealed to explain how they're going to transfer these functions, which require hundreds of investigators and attorneys experienced in education law, and move it to an agency that, as we know, has already itself been depleted of a lot of its existing expertise, and bringing in a whole new function with a whole different mindset and a different culture that's needed to reach these resolutions in so many individual fact-specific cases.
I think you really kind of captured, they both have functions currently. For over 60 years, OCR has been doing this. As a parent or a family member or a student, I know I could go there and they would look at mine compared to DOJ, which is looking for those patterns, which is looking at systemic change, macro change. And then you also talked about just the specific nature and expertise that's required to do this at the Department of Education. You also really preempted my next question, which was, do you think that the Department of Justice has the capacity to assess every civil rights complaint like OCR does?
As currently constituted, absolutely not. As constituted, even in the Biden administration, they wouldn't have had the capacity to do this. And then putting in perspective, I think 75% was mentioned as the exit rate at DOJ. There's just not enough people there. And even if they could hire hundreds of people in a day, which they can't, those aren't going to be the right people. Those aren't going to be the people who have had the experience in the educational systems, who have the knowledge particularly around specialized areas like a free, appropriate public education and specialized accommodations in higher education. Those are very niche areas. And I'm not saying that DOJ doesn't have really smart lawyers. They do, but they don't have lawyers that have been trained up on these kind of individualized investigations and resolutions.
Even before this announcement of the IAAs, the Office of Civil Rights under this administration had already begun to be weakened. Mr. Galanter, you noted in your testimony that OCR reached just 112 resolution agreements in 2025, a 12-year low. How does this number compare with when you were at the agency?
I wish I had those numbers at my fingertips, but it was a 12-year low. So all the years I was there, we did better than that.
I actually have it at my fingertip. 507 cases in 2024.
Yes. You have to remember that with almost 600 employees, which was something that the Biden administration worked really hard to achieve, we were able to staff many of our offices. We implemented rapid resolution procedures, we had mediation, we had all kinds of systems in place to help get to quick resolutions. Because as I think Ms. Williams was saying, delay for a kid is particularly harmful. When a kid can't go to their graduation because there's not a ramp, or because they, some other disability-related function, or because they aren't allowed to play a sport, those things have an immediate impact that can't be solved a year or two later. And so OCR really was devoted to quickly resolving as many of these cases as we could. And also, when we saw that there were systemic problems at a school, we looked at them and we fixed it systemically, but not at the expense of any individual complainant.
I have a question for the entire panel, and it's more forward-thinking. I'll say when Democrats take back the majority, what is the first policy we should implement to restore protections for students with disabilities? And if I could start with you. Yeah.
Thank you for the question. It's a very good question, to be honest with you. I'm going to do a little bit of a preface to that. Before we really look at policy change that we would have to be accountable for implementation or hold accountability around, we'd have to ensure that we have the right staffing in order to be able to uphold that. So a policy change in and of itself, I know I'm kind of skirting your question, but a policy change in and of itself, okay.
Because you could actually say, I would recommend, it doesn't have to be a policy change. What would you
Okay.
do
So
if you were us?
a policy change in and of itself, unless we have the appropriate resources to hold accountability around the implementation of that, provide the technical assistance that's necessary to provide the interpretation, from a statutory regulatory perspective, would be naught. So we really have to make sure that we have the right resources and supports in place, and that is a significant concern that I think all of us on the panel have articulated, is with the absence of having the qualified personnel to really uphold IDA as it's intended. So we do have probably recommendations around policy change, but the prerequisite to that for me would be making sure we have the appropriate resources in place to be able to implement the policy as intended and written.
Thank you. Ms. Neese?
So I would have two things. One is the law itself is great. The regulations are great. The implementation thereof is not great in too many places. So really a commitment to monitoring and technical assistance, really beefing that up so that the department could really partner more aggressively with states to fix problems before they become bigger problems. The second thing I would do is I would, well, there are two, Part A, Part B. One is for so long, the lack of funding in what I call Big B, the primary state grant program, has been used as an excuse to why states and districts can't meet their obligations under the law. And just to reinforce, IDA is a civil rights law. The fact that Congress gave states money is a bonus, right? But at the end of the day, it's a civil rights law. So we need to have states have incentives to have state funds and local funds be increased, as well as federal funds. There's some things that you can't do without more money. You can't hire another teacher without money. You can't hire another speech therapist without money. You can't provide a piece of technology without money. But the values that people bring and the understanding that comes from knowing your roles and responsibilities comes with training. It also comes with personal intention, and you can't buy that, right? But you try to create a system where that can happen. And a smaller piece of that is funding for the early intervention program. And one of the beauties of the early intervention program is the support it gives to parents and families about how to navigate the system, about how to have high expectations for their child, about how they can, at the beginning of this journey with their young child, that they can dream of success and progress. And we don't serve every kid who could benefit. And if I had a dream, it would be we could serve every kid who benefit. And I know your state has been a leader in this for as long as I can remember. But that helps kids and families when they get to school have some experience about navigating the system, about really knowing what their child is capable of achieving. And I wish that for every family.
Thank you. Ms. Williams?
Thank you for the question. I echo everything that's been said already about funding, about staffing, about the technical assistance, which is oh so critical. From a systems perspective, I think that one of the things that we can start doing right now is resist the urge to restore at a later date, resist the urge to restore whatever is being lost right now. And I think what we need to do is think about, what do we always believe IDEA could and should be? And how do we think about transforming it to that and moving forward instead of looking backward and trying to reinstate things?
Thank you. Excellent. Thank you.
From my perspective, it is a little bit of a Humpty Dumpty situation. We had some great institutions at the Department of Justice and OCR. Building them back won't be easy. It will take money and it will take time. I wouldn't have thought you would need to say this, but if Congress could say, you have to spend the money that you're given to actually hire people and to do their jobs, and not just bank it and give it back to the Treasury, that would be something that could be done, even during this administration. I think also we need to be looking at alternative methods of enforcing rights. The protection advocacy systems is an amazing model that Congress has set up to advocate for people with disabilities. It is, in every state has a protection advocacy system, and they are, like everyone else, overwhelmed with parents looking for help, looking for advocacy assistance. Those kinds of systems, which haven't, felt the lash that many of the other agencies have felt, might be another way to provide independent and consistent support for parents and students.
Thank you. Ms. Tong?
I have two suggestions that come to mind. One is about just making sure that we reverse all of the harm that's been done under this administration. If you look at the Department of Education's regulatory agenda right now, there are so many harmful regulatory actions that are taking place. And one of the ones, as an example, I'll call to mind, is a final rule that rescinds non-discrimination protections for students with disabilities, students of color, and girls in career and technical education. So that's just one example of many. But that, those protections were so important because it was a system of enforcement that made sure that we don't have students with disabilities, Black and brown students and girls, segregated into these fields of study and later into their careers in low-paying fields, right? We don't want to go back to a time of segregation. Occupational segregation is harmful. I think hopefully that is a bipartisan issue that everyone can agree on. But that's one of the things that I think we need to do, is just focus on what this department is doing right now and make sure we are capturing all the changes and make sure we reverse. But as my colleagues on the panel have said, we also need to be building forward, right? We can't just go back to the status quo. And, staffing is a big concern. OCR has been under-resourced for many, many years. If you look at 1981, right, the first full year of operation, there were 1,100 full-time employees, and they received 3,000 complaints that year, okay? If you look at 2024, even before this administration took office, there were only half as many staff, and as Mr. Galanter said, the Biden administration actually worked hard to get there. It was even lower before that, okay? So the office has been under-resourced for years, and guess what? The number of complaints that is received has grown by 8 times. So if you take half the number of staff, 8 times the number of complaints, even before this administration took office, it was operating at 1/16 the capacity that it was when it was created. Then you take the reduction in force that happened, that's another half. So now we're operating at 1/32 of its original capacity. So that's a big problem. And of course, if you say, well, let's make sure we go back to the status quo, we'd still be at 1/16. And so OCR has been level funded at $140 million for the past many years. And so what we are asking for is to fully fund OCR. For many years, the civil rights community has asked for at least double the funding. And double the funding is not going to get us to where we need to be. You heard the numbers. But it's definitely a step in the right direction. And we also need, to make sure that money is being spent, right? Make sure we are hiring back staff with the institutional expertise in order to make sure that we can actually have an Office for Civil Rights that does the job that Congress intended for it to do when it was created.
Thank you so much, and I yield back, and I don't know, Senator, if you'd like me to introduce Senator Chris Van Hollen?
Thank you. Thank you to Senator Blunt Rochester for all your work in this area, and of course to Senator Hirono for bringing us together and sharing this. And sorry you've lost your voice. We will all try to, fill in as best we can. Yeah. So thank all of you who are on this panel for your years of service and for being here right now to shine a light on everything that's happening under this administration, but also providing some context about how the Office of Civil Rights and OSERS were under-resourced even before, and now even more damage, much more damage being done. And so what I'd like to know is how families who have students with disabilities are trying to navigate this particular moment, because most of us have been trying to look forward and see how we can actually strengthen the special education program, whether it's through policy reform or funding. I've continued to push for the IDA full funding legislation. Thank all of you who've been supporting that effort for a long time. Thank you to Senator Hirono. So I'd much rather be in a position where we're trying to make good things happen than trying to prevent harm to the Department of Education and the effort to make sure that we address the civil rights of students and make sure that people have the special education opportunity that the law requires. But here we are, and so as was pointed out, I think Ms. Tang just pointed out, and all of you have sort of reinforced this, that OCR and OSERS were already understaffed. There were already backlogs, long backlogs of cases. But now we're talking about, taking a situation that was far from perfect and transferring those obligations and responsibilities over to DOJ, but with less resources and less expertise. And so for the families with, kids with disabilities who are facing this moment, what are you hearing from them in terms of their concerns about an inability to make sure that their kids get the education they want? I don't know if it's best to start with you, Katie.
Yeah,
It's good to
I
see
can
you.
start. Yeah, nice to see you, Senator. We've been asking our chapters, and we're hearing sort of two general themes. One, families are tired of beating their head against the wall, so they're pulling their kids out of school and homeschooling them. And they don't feel like that's the right answer, but they don't know what other right answer is available to them. The second thing we are hearing is more families using the state complaint process, but that involves hiring a lawyer. And as everyone on the panel has said, the OCR route, one doesn't require a lawyer, and two, if the law is implemented properly in the first place, you don't need a lawyer, right? You don't need to file a complaint if you're getting what the law entitles to you to receive. We have heard things from schools refusing to do an initial evaluation, schools not willing to do an evaluation for IDEA eligibility, but willing to do a 504, which is a totally different ballgame. So it all depends on the knowledge of the person at the school or school district you're dealing with, and if they have incorrect or incomplete knowledge, you get a bad answer, and then families have to either file a complaint and then go through that process. And as everyone on the panel said, but especially Valerie, children get older from Monday to Tuesday. They don't have time for us to get it together to figure it out. And so that's why a lot of the families that we are working with have just thrown up their hands in defeat. And they know that's wrong, right? They know they don't have the expertise, but they're attempting to make the best of a bad situation they feel is a better response than trying to continue to fight to get what their child needs.
I think in the absence of any transparency with the department and any clarification on what their plan is around the implementation of the programs and services, that's what's creating the anxiety for the families. We don't have answers. We've asked for answers. We've asked questions. So I think it's the unknown that's really creating the misperception or the concern that is putting a little bit more pressure on parents to utilize some of the dispute resolution processes that we've talked about earlier today. So I think that parents are unsure of what programs and services are going to look like, what the funding are going to be. They're very concerned with not having qualified special education personnel providing services to their children. But now at the federal level, the uncertainty of will the resources be available to be able to meet the individual and unique needs of their children moving forward. So it's
Thank
the
you,
lack of
Senator Corona,
transparency.
for holding this hearing and
I'll jump in. To your question, Senator, thank you. Navigating for parents right now is becoming increasingly difficult. I talked to a related service provider 2 weeks ago, and she said someone in her school building asked about IDEA, and someone else responded and said, "We don't do that." That was the response. So OSEP funds parent training and information centers, one of our greatest investments. In every state, there's at least one. In larger states, there's more than one. These are places that parents, educators, anyone can go to and get free information about what's going on with IDEA, not just from a federal perspective, but from their state. And as we have been going through this exercise, their caseloads have been increasing, and they're not able to keep up. And what we know about school districts and states is that when they don't know and they're not getting clear guidance or any clarity, they either freeze or they guess. And either way, the student bears the brunt of that.
Yeah. Well, I can understand that we're hearing from constituents as well, right, who have kids with disabilities, and they have no idea where to turn at this moment. If I could ask also about at least the OCR. OCR is going to DOJ, OSERS is going to HHS. In my view, neither of these other agencies or departments have the expertise able to handle their piece of this. Let me start with the DOJ piece and OCR, because I'm the senior Democrat on the Appropriations Subcommittee that funds the Department of Justice. And as you probably know, this administration has just taken a chainsaw to the professional staff at DOJ. I mean, they've lost a lot of their lawyers and other key staff there. And so the idea that they're going to take on these new responsibilities that they have no expertise in is clearly a failed strategy. On top of that, and this is the question I wanted to ask, you've got an administration that essentially is challenging the fundamental principle behind the Olmstead decision regarding individuals with disabilities being able to stay in the community. And so it really worries me that they are essentially taking these special ed functions out of the Department of Education, where education's been the priority, right? The fundamental idea here was the civil rights idea that every child's entitled to a quality education. And they're instead putting the OCR piece into a Justice Department that seems to be hostile to the idea of individuals with disabilities becoming part of the community, an inclusive vision. And also the OSERS piece to an HHS that also doesn't have an educational mission in any way. So in addition to the resources issue, could you just speak to the dangers ahead about providing these agencies, these other agencies with this very different viewpoints, the responsibility for the education of kids with disabilities? And maybe, I don't know if we want to start with Ms. Williams, and I don't know, maybe start with the lawyers, or anybody's free to comment.
I'll jump in and start. In regards to the personnel concerns, HHS is not equipped to execute education programs. That's not their expertise. And I think it would be atrocious to ask an agency to do this critical work for 7.5 million children across the country when they don't have the expertise, because we know it's in the U.S. Department of Education. And they are not aware of how to do some of the simple functions in terms of infrastructure, the monitoring, the constant oversight, the sometimes daily communications with state education agencies. They are not familiar with that, and that's not their expertise. They're good at what they do, but what they do is not education. And in reference to the harms ahead, as I mentioned earlier, HHS operates on a medical model, and we're not talking about a diagnosis and needing treatment. We're talking about kids that we are working to educate.
Yeah, thank you. Very different missions, as you pointed out. Yeah.
In addition to the absence of resources and staff, there are two other things that would make it difficult for DOJ to replicate the function that OCR currently provides. One is that Congress set up OCR kind of as an independent component within the Department of Education. The Assistant Secretary was delegated certain functions by Congress, and she performed those functions without interference from other components in the department. She didn't have to brief the secretary to get approval for things before she did them. Although she worked with OSERS, she didn't need OSERS coordination, OSERS consent to move forward with investigations or resolutions. DOJ has a very different model. Its Civil Rights Division is plunk center in the middle of oversight by the Attorney General, the Deputy Attorney General, the Associate Attorney General. Its decisions are second-guessed and micromanaged across the department. And if you put 20,000 decisions about whether to open complaints, how to resolve cases, in that kind of system, not only is it going to be incredibly slow, but you are going to see, I'm afraid, the bleeding in of politics to what has been a pretty neutral process of civil rights enforcement. The other thing I'll note is that OCR did have a regional model. That is, there was a vision that being closer to the school districts, the parents, the state education agencies made OCR more effective. In a state like California, it had its own regional office. Other states shared, but like there were relationships built, and there were economies of scale that allowed enforcement to work better at a local level. I mean, DOJ has U.S. attorneys' offices, but we have no idea. None of them have the expertise that we're talking about here. And so we're moving from a regional dispersed model to a centralized model where Washington will be enforcing these laws without regard to any kind of local or regional circumstances.
Thank you. That was helpful. Ms. Tang?
Just to add on to what's already been said, historically, DOJ has referred the vast majority of the complaints it receives regarding education to OCR. So now the idea that with this interagency agreement is that OCR sends the complaints to DOJ, it doesn't make any sense. That's the opposite of it, right? It doesn't make any sense. Furthermore, the interagency agreement doesn't mention any transfer of staffing. It mentions transfer of money, but there's no indication of how CRT is going to be staffed in order to take on all these new complaints. And so when you ask about the harms ahead, I think what we'll see here is that students will have a right without a remedy, right? They will have the right to file an OCR complaint and the right to see it go unaddressed. And in the long term, what they're going to think is, well, there's no reason for me to file a complaint at all if no one's going to be there to help me. And if you have fewer complaints, that doesn't mean that discrimination is going to stop. It just means that we won't know what's happening. We'll have less information. And of course, this has been the administration's strategy across many different issues. Stop collecting data about a problem, and then we can just pretend the problem doesn't exist. But discrimination will continue, and if reports are reduced, complaints are reduced, if accountability is very rare, actually discrimination might increase. And so that is the harm ahead. And of course, this is a very bleak picture, but we can stop it. And all of us advocates here and in the education and civil rights community are ready to support you as members to introduce legislation to block these transfers.
Well, thank you, and thank all of you, because the purpose of this spotlight hearing is exactly as you say, to help draw more focus onto this very dangerous moment, dangerous for, our commitment to kids who have disabilities, making sure that they get a first-rate education, and our commitment to their families. And I do think if we need to do everything we can to stop things from getting a lot worse, because if you stop the enforcement, if you no longer have the expertise, it's very likely that we're going to see things get worse around the country when we want to get back to trying to making them better, as I said. So again, thank all of you. Thank you, Senator Hirono, and I see our colleague, Senator Durbin, who of course is the senior Democrat on the Judiciary Committee and has been leading so many of these battles over so many years. So thank you all again, and I'll turn it over to you, Dick, because
Go ahead.
Senator Hirono, I'm the ventriloquist right now.
Thank you, and thank you for this hearing. By virtue of my seniority on Earth, I remember the 60s personally. And I can recall being in college and law school during that period of time and witnessing the Great Society and a lot of changes in Washington with President Johnson and others. And I found a lot of the experiments in the war on poverty to be fascinating in terms of what they taught us. One of the more interesting ones we still talk about and is involved in some controversy today is Head Start. And the fact that Head Start, which would almost by definition be a school program, was not, spoke volumes. Why was it separate? I believe my impression is that it was separate because people in Washington creating this program for young children couldn't trust the school districts of America. They weren't sure that in certain areas of America, poor kids in need of help would be given a chance in the school system, particularly kids of color. So they went their separate way, and Head Start became an operation and an agency which served children at an early age and was not necessarily engaged or involved in the school system. I think of that conscious decision being made in Washington for a national program sensitive to the racial impact it could have, and the decision, a rather bold one at the time, to go their separate way. And I try to contrast it with the exact opposite of what is happening today with this administration. And the fact that they not only don't have sensitivity to issues like racial disparity, but they seem to want to fly right into the face of it, to rewrite history where they can, to eliminate programs that are dealing with or arguing for equality, and to basically say, we're not going to let you tell the story of America, where race has been an issue since the 17th century. I mean, that to me is so obvious, Voting Rights Act and other places. I'm just wondering your thoughts. Am I wrong in the way I see this? Have I missed some key elements? The Department of Education was created in the 1960s, and I think for the same purpose, to make sure the school districts of America fought fair when it came to giving kids a chance. And now this administration, the Trump administration, wants to dismantle that effort and frankly doesn't give much of a damn about special ed and racial disparities and their impact on education. Ms. Williams, start us off.
First, you are not wrong. It seems to me that when you support public education, and your policies support public education, your funding supports public education, but that's not what we're seeing right now. We're seeing politics that are prefer to promote other types of education, which are fine, but we still need to support public education. Public education is the only place where a child that comes from a low-income background, a child with a disability are guaranteed certain things in the public school system. A child with a disability is not going to get a free, appropriate public education anywhere else. And we run the risk of only having kids of low income and kids with disabilities in public schools. And that's not equitable.
So let me tell you that I am a product of 19 years of Catholic education, okay, start to finish. I was born and raised and grew up in a town called East St. Louis, Illinois. Here's what I learned. We had our Catholic parishes, we had our Catholic schools. When the public school system went to hell in East St. Louis, so did the Catholic schools. They couldn't maintain and sustain livelihood and neighborhoods when the public schools were subpar. People just wouldn't live in the community. They headed out to the burbs, and I could list them all for you. Anybody in the area knows what I'm talking about. And so, even as a product of Catholic schools, I saw the value of public education very early in my own life. The public schools had to be doing their job, that's for sure. When it came to special education, I have a new level of expertise. I am what they call a grandfather. And one of my grandchildren deals with dyslexia. And I can tell you, without naming names, I could, but I'm not going to, in a major city of this nation, the major league school district isn't worth a damn when it comes to treating special ed kids with dyslexia, from my point of view. We've got a lot that we need to do, and I don't think what this administration is proposing is any help whatsoever. It is beyond, I think you were the one or someone said, it's beyond the diagnosis. It's a question of education with the diagnosis, and that, I think, is missing in this analysis. Would anyone like to comment on that?
So, Senator, you're spot on. One of the things about the beauty of IDEA is in the public system, where we have an expectation that every kid should have the chance to learn the regular curriculum and master the regular curriculum because they get the right supports they need to do that. For a child who has dyslexia, it's how do you teach them to read? How do you teach them to comprehend reading? And we know how to do that. We just don't do it. And so what the public system needs to do is be better at that. You mentioned Head Start. In 2007, there was a reauthorization of Head Start, and we were able to put performance standards in. And Head Start, since day one, has reserved a portion of their slots for kids with disabilities because the crafters said poor kids and poor kids with disabilities can benefit from this comprehensive early education program. And the beauty of it over the years is it went from serving just kids that had speech and language delays to serving kids with all kinds of disabilities because the staff had the training and support and the specific guidelines they needed to meet to get the job done. The administration may, in the next couple weeks, issue a proposed rule that eliminates all of that. And again, we have seen when you eliminate the oversight, it's not good for kids. It's not good for families. It's not good for schools. And so we need more support, more technical assistance, more trained special educators, more educators who know how to work with the special education providers. That's how you get success. And we have to have a robust public education system because, as Valerie said, with the voucher provision that was in the big, beautiful bill that Senator Horono, you had a spotlight on last year, families are going to, those that go to private schools, the state still has the obligation to meet the educational needs of students with disabilities. But if there's no money in the public system because it's gone to the private system, parents are going to access their due process rights, sue the state, and win. But what are they going to win, right? If the system is so replete of money to do what needs to be done, it's going to be a hollow promise.
You worked for Tom Harkin.
I did.
My predecessor, Paul Simon,
Yes.
also served on the education committees, and I can recall the great personal pride he took in terms of the standards we established
Yep.
for teaching disabled children.
Absolutely.
I will tell you, in 19 years of Catholic education, and I don't hold it against him because it's just an economic reality,
Right.
very few disabled children.
Right.
And very few programs for them in private schools. And so their only hope was a public education. in hopes they can come up with the resources to make it work. And this administration is, of course, squeezing them when it comes to those resources and discouraging a generation of special ed teachers in the process, as far as I'm concerned. But there are champions on Capitol Hill that succeed Tom Harkin, and one of them is our presiding
Yes,
chair
absolutely.
of this meeting. And Senator Hirono, thank you for picking up this education issue and making it your
you.
own.
Thank you, Senator Durbin. It is clear that this regime does not support federal support for public education. Before we end, and I want to thank you, Doug, you weren't here, I'm losing my voice. We have one more virtual witness, and I'd like to have that video put on. It's Ms. Stephanie Smith Lee. She's the co-director of policy at National Down Syndrome Congress, and if we can turn that on. But I want to thank
Thank
all
you,
of you
Senator
for testifying.
Corona, for holding this hearing and for your leadership on behalf of students with disabilities. My name is Stephanie Smith Lee, and I'm the Policy and Advocacy Co-Director of the National Down Syndrome Congress, and I served as Director of the Office of Special Education Programs, or OSEP, under President George W. Bush. I want to begin with something I learned during my years at the Department of Education. Special education does not work in isolation from education. That may sound obvious, but it is at the heart of why I believe special education belongs in the Department of Education. Students with disabilities are students first. They participate in general education classes, they graduate from high school, and seek higher education and employment. Their education should not be separated from the federal agency responsible for education or from other education programs. I saw that value firsthand as OSEP director. The Individuals with Disabilities Education Act, or IDEA, works because the Department of Education combines accountability with partnership. OSEP monitors states to ensure compliance and accountability. OSEP monitors the states, and it also helps states succeed through guidance, technical assistance, data, and support for families and educators. My late daughter Laura is one reason this matters so much to me. Laura was born with Down syndrome in 1982. When she was born, my husband and I were told that she might never learn, work, or live in the community. We were even urged to put her away. Instead, Laura received early intervention and transition services, had access to the general education curriculum, and attended an inclusive college program. She took the subway into downtown Washington, D.C. to her job at the World Bank, and she lived in a townhouse with support. Those predictions about Laura's life were wrong. Her life reflects 5 decades of progress in educating students with disabilities. Before the first version of IDEA was passed in 1975, more than 1.7 million children with disabilities were excluded from public schools, and approximately 100,000 children with disabilities lived in institutions. Today, more than 8 million infants, toddlers, children, and youth receive services under IDEA. We should be building on that progress, not dismantling the federal infrastructure that helped make it possible. Moving special education to the Department of Health and Human Services, an agency focused on patients, not students, would separate it from the rest of federal education policy and weaken the expertise and coordinated oversight that students, families, and states depend on. The same is true for civil rights. Students with disabilities need a strong Office for Civil Rights in the Department of Education. Education and civil rights are inseparable when the issue is whether a child has an equal opportunity to learn and is protected from discrimination. I know that the system is not perfect and improvements in the implementation of IDEA need to be made, but improving a system is very different from dismantling it. Supports for students with disabilities and IDEA has always been bipartisan. I joined with a bipartisan group of former federal special education leaders from every administration going back to the Nixon administration to urge Congress not to transfer special education to another department and not to dismantle the Department of Education. The federal government should not make it harder for states and schools to partner with families and implement a law that Congress enacted to protect the educational rights of students with disabilities. For families like mine, this is not about defending a federal department. It is about protecting a federal commitment to children. Laura's generation benefited from that commitment. The children coming behind her deserve the same opportunity. I urge Congress to keep special education at the Department of Education, stop the dismantling of the department, and focus our efforts on what matters most, ensuring that every student with a disability has the opportunity to learn, contribute, and thrive. Thank you.
So clearly, we need to alert the American public as to what is happening with this regime and its lack of support for public schools and for this hearing, in particular IDEA. These are not normal times. In normal times, you wouldn't have a department dismantling itself and its programs. So I'm asking all of you to help us alert the American public and to fight back, because the dismantling of all of the infrastructure, the 50-year infrastructure to support IDA is definitely taking us backwards, and we need to fight for our kids. I want to thank you for your patience, and believe me, normally I have a lot more to say, but we'll continue, fight back.
Chair, Madam
Mahalo.
Chair. Madam Chair, can I suggest warm salt water?